Tēnā koutou katoa, no mai, haere mai. Welcome to webinar 7 about the creation of new powers or entities. In order for the executive, legislative and judicial branches of government to act, they require some form of authority to do so. The power to do something may be granted by the common law or may stem from natural powers of a legal person, for example, the ability to contract. If not, then legislation is required. This webinar explores some of the key questions to consider when considering creating new powers. First, is a new power actually required? If so, who should wield it? Is a new entity required? And finally, what safeguards ought to be included? In a moment, I'll introduce our panel members, Dagny and Jonathan. But before doing that, I'd like to do a couple of things. Firstly, let me introduce myself. I'm Guy Beatson. I'm one of the deputy chairs of LDAC. I'm also a non-public service member of the committee. My day job is General Manager Governance Leadership Centre at the New Zealand Institute of Directors, where I lead thought leadership, policy and advocacy, and as IOD's Registrar, I have responsibility for Director Professional Standards. And oddly enough, given the topic of today's webinar, my background is in economics rather than law. Secondly, I'd like to introduce you to LDAC and give a bit more detail about today's deep dive webinar. The Legislation Design and Advisory Committee is made up of members appointed by the Attorney General to support good legislative design. It has a mixture of public service and non-public service members. All of the members are voluntary or unpaid for their LDAC work. In the case of public sector employees, their time is loaned by their employer. PCO provides secretariat support, including advisors to support the committee. Members have a broad range of backgrounds. We draw members from legal and policy teams within departments, Crown entities, as well as academics, lawyers, barristers, and consultants. A broad range of experience and skills is important because good legislative design is multidisciplinary. It's not just about the law. And LDAC has three functions. We publish and maintain the legislation guidelines and supplementary material. That's government's handbook for good legislative design. The most recent edition was updated in 2021. But the guidelines have a decades-long history and are direct successors of the LAC guidelines. We carry out education and engagement activities, like this session today, but also by department and by issue. Both these activities extend our reach beyond our advice functions. It's common to see submissions to select committees referred to the guidelines, and ministers are required to address consistency with the guidelines in cabinet papers for bills. Our advice function applies at two different stages. The bulk of our advice work is prior to introduction, when we advise departments that come to us. We also make submissions to select committees. We aim to support good lawmaking. We're guided by the guidelines and supplementary material. The guidelines are not about policy. They're about expression of policy in law. This means you will not find us giving an opinion on policy. It's important to remember that the guidelines are just that, guidelines. These are not rules that must be followed. Our goal is to help ensure that conscious design choices are being made. In today's webinar, we're going to look at three areas. The fact that all parts of government need legal authority, as I said at the beginning. We're going to talk a little bit about powers and authorities to do things and how it comes from several sources. And last of all, we're going to answer some key questions: who, what, where, and when for both new entities and powers. So let me introduce our panel members today. Firstly, I'd like to welcome Dagny to our panel today. Dagny is Principal Solicitor in the Office of Legal Counsel at the Ministry of Justice. Can you tell us a bit more about you and your role, please?
Thanks, Guy, and kia ora koutou. As Guy said, my name is Dagny and I work in the Office of Legal Counsel at the Ministry of Justice. That's my day job, and I'm also a member of LDAC. At the ministry, I provide advice to the larger ministry and to the minister on a range of justice sector, constitutional and public law issues. And the main areas that I work in are vetting proposed legislation for consistency with the Bill of Rights Act and miscarriages of justice.
That's great. Thanks, Dagny. And you're well qualified for the conversation we're going to have today. And can I now turn to Jonathan to introduce himself?
Thanks, Guy. Kia ora koutou, everyone. My name Orpendale, and I'm one of the non-public service members of LDAC. My day job is a barrister, where I have a recent amount of my practice in public law work split between acting against government and for government clients. And so that work tends to sit at the other end of the process, looking at how legislation applies in practice and the pitfalls that sometimes get created.
That's great. It's really good to have both of you on the panel today, with that public service legal point of view on one side and a non-public service looking in type view that Jonathan's going to provide. Before we get into the discussion, I'm sure that you're going to have questions as participants. Please don't wait until the end of the discussion to ask those questions, and you can ask them at any time using the Q&A button at the bottom of your screen. So now let's get going. We're first going to talk about creating a new statutory power. So if we can start with Jonathan, when might the creation of a statutory power be required?
Thanks, Guy. As you said in your introduction, the starting point is that legal authority is always needed before a public body can act. And as you've indicated, this authority can come from three main sources. First, you can have a statutory power that's conferred by Parliament. Secondly, we have common law powers. And thirdly, sometimes powers that are held by natural persons that public entities may be able to use. For example, as you indicated, the power to enter into a contract. So in terms of when a new power is going to be required, you'll only need to create a new statutory power if there's no existing suitable power that achieves your policy objective. So as part of your policy design process, you'll need to ask yourself first, what needs to happen to achieve the policy objective? And second, is there already a source of power that can allow for that to happen? In carrying out that analysis, you'll want to be careful to ensure that consider each of your sources of power, and in doing so, only create a statutory power if it's necessary. So in terms of looking at legislation, the LDAC guidelines advises that duplication of powers can create unnecessary uncertainty in the law and can also have unintended consequences for the interpretation of other acts. So if you've got an existing power, we would generally recommend not creating a new power to duplicate it. The same goes in relation to the common law. You need to give careful consideration to whether or not the powers that you might have at common law are sufficient. It's not generally a good idea if you've got sufficient powers at common law to restate it for the avoidance of doubt basis, because this can also have unintended consequences in your legislation and across the wider statute book. Of course, there are cases where you do need to create new statutory powers, and the clearest case for that is if you're creating a new entity or giving a new function to an existing entity. And in those cases, a new statutory power will almost always be required.
Hey, thanks, Jonathan. That's really good. That's a really good introduction in terms of how we go about this. If we can turn to Dagny. So we've talked about powers and so on and so forth with these entities. So what are the different forms of powers that a public body may need in order to act?
Well, they are not necessarily able to be classified in a rigid way, but you can speak broadly about some different types of powers. Sometimes they overlap, and some of them are more suitable to different kinds of policy outcomes than others. So broadly speaking, the categories can be described as, legislative powers. So that's a power to make or alter the content of the law. And if the power that you're creating is a legislative one, then the Empowering Act must identify it as being a legislative power or one to create secondary legislation. The second type of power we can describe as administrative power. Now, that's the power to apply the law to a particular case or in a particular scenario. The third type of power we can distinguish is the adjudicative power. Now, that's different from an administrative power because that's a power to determine rights or obligations in a particular case, and often that's about determining disputes between people. And then the fourth category of power is a persuasive power. And that's something that can be a little bit more nebulous. It's the power to influence action without compulsion. For example, like a power to produce a strategy or some guidance documents. These powers can stem from the natural powers that a legal person has to do things. And it's not always necessary to provide for those powers in legislation. However, sometimes legislative source of the power may give greater weight to that persuasion. For example, things like guidelines can have more power if they're in legislation.
So that's a really, really neat categorization that I hope our participants today can pick up on. But it does lead to the obvious question about how should you decide what powers and which types of powers are required? Dagny.
Right, that's a good question. So the type of powers that you need should be led by the nature and characteristics of the body or the entity who'll be exercising that power, and of course by the functions that they'll be carrying out. So the key thing here is to make sure that the body or entity that you're giving these functions to has all the powers it needs in order to be able to do that function. For example, if the body is a regulator, you'll need to think about how they're going to measure compliance with and enforce the regime that they are regulating. You know, what powers do they need to do the monitoring they're going to have to do? Do they need powers to compel participants to give them information? Do they need powers to enter premises and observe what participants are doing? Do they need powers to search for and seize information or things? Or do they need other types of powers to make participants in the regime do things? These are some of the questions you'll need to work through.
Yeah, and we'll come back to some of those, including search and seizure in a bit later in the webinar. But for now, having looked at creating a new statutory entity and thinking about who should hold those powers and what those powers are, I want to turn back to Jonathan and talk a bit, or get him to talk about what should be taken into consideration when thinking about who should hold a statutory power.
Thanks, Guy. When you're thinking about that question, you really need to think about it at two levels. First, there's the issue about which branch of government should hold the power. Is it going to be held by the executive, the judiciary, or the legislature? And secondly, once you've decided where it's going to sit amongst the branches, there's then the question about what level within the branch the power should sit. And in terms of answering the first question, the nature of the power will usually give you much of what you need for the answer. Most powers are held and given by the executive branch, with the main exception being adjudicative powers, which usually sit with the judicial branch either through a court or a tribunal. In terms of the second question about the level in which you want to give the powers, there are a whole range of factors that should be considered here when deciding who will hold the powers. And the LDAC guidelines in Chapter 18 include quite an extensive list of, I think, about 16 different considerations. We won't go through all of those in the webinar here, but two overarching factors that come out of that, which I think are worth highlighting, are the question of expertise and accountability. In relation to expertise, you want to make sure that the person that holds the power is someone that has the necessary expertise to exercise it properly. And in answering that question, you want to give consideration to the nature of the power again and the issues that will need to be considered in exercising the power. If the considerations are political or policy-based, it may be appropriate for that power to be exercised, for example, by a minister who's democratically elected. And then at the other end of the spectrum, if the considerations are technical, the powers may more be appropriately exercised by public officials with the relevant expertise. That, of course, needs to be balanced against the question of accountability and which involves asking how those tasked with exercising the powers will be held to account. And again, the nature of that power is important. If the questions are of a policy nature, political accountability may be necessary or required. But in either case, what the guidelines do stress is that the more significant the decision is, the more senior the person should be who ultimately makes the decision. And for reasons of simplicity, it's usually preferable to place a more significant power with the person who has the ultimate accountability for the decision, be that chief executive or a minister, depending on what side of the policy line it sits on.
And that's a really nice simplification, Jonathan, of 16 things that we would otherwise think about. So just to pull all that together, authority is required for public bodies to act. The sources of that authority may be statutory or it may come from common law. It's really important not to duplicate existing powers, as this can create uncertainty and may result in unintended consequences. And as we've outlined, there are 4 types of powers conferred by legislation. Officials often have a choice between these types as more than one may be capable of achieving the policy objective. And that's an important consideration. That says there's got to be deliberate decision-making about those things. And lastly, the types of powers and who is responsible for exercising them are linked together. Individuals and entities should only be given powers that are consistent with their role in the system and their accountability, and as Jonathan's pointed out, their expertise. So at this point, let me just make a quick reminder. This discussion already will have raised some questions for you. If you have them, please don't wait until the end of the webinar. Please ask your questions using the Q&A button at the bottom of your screen, and we'll answer them once we've talked a bit more with the panel. So let's move on. Let's talk about creating new entities. When is it justifiable to create a new entity, and what considerations should be met, Jonathan?
Well, the first thing that needs to be borne in mind is that creating a new public body involves considerable expense. So as a result, a compelling case always needs to be made to justify the establishment of a new agency as opposed to giving powers to an existing agency. And generally speaking, a new agency should only be considered if each of these factors applies. First, the proposed role or function is incompatible with that of an existing agency. Secondly, and relatedly, it would not be feasible or appropriate to expand the role or functions of an existing agency. And this might be the case if there are strategic or operational reasons why no existing agency's functions or roles should be expended to carry out the proposed role and associated functions. In that context, it needs to be borne in mind that the operational reasons, if that's the basis for not expanding an existing agency, will need to be carefully identified and considered. Because even if some restructuring is required to an existing agency, it's usually more efficient to do that and give new powers to an existing body than to create a new one. Thirdly, and this is also important for a practical reason, a new agency shouldn't be created unless ministers are willing to commit to providing the necessary capability and financial support for at least a 4-year budget period. There's no sense setting up a new agency if it's not going to have the funds to be able to continue. And then lastly, and this is really an overarching point, the establishment of a new agency can be justified in cost-benefit terms, which will involve asking some of those earlier questions, but others as well.
Yeah, that's really good. And it's a really useful checklist about how to do this to avoid confusion, but also to avoid expense. But I think, Dagny, you've had some relatively recent experience of a new body, which is not quite the same as creating a state-owned enterprise or something equivalent. Do you want to talk about that?
Sure, Guy. The interesting example that I've had some involvement in was the creation of the Criminal Cases Review Commission. This was a new body that was set up in 2020 legislatively to carry out the function of referring criminal cases post-appeal back to the courts for further consideration. Now, what was interesting about this function was that this wasn't an example where there was no existing agency doing this, because this was something that was already being done by the Governor-General on advice from the Minister of Justice, supported by the Ministry. However, there was a very strong policy desire to have that particular function carried out by a separate body that was completely independent of government and the Ministry. So there were a lot of really strongly argued policy reasons to put this function into a different agency. And at the same time, the opportunity was taken to expand some of the powers that that new entity would have. So, for example, it was given some broader investigative powers than those that the Ministry had been able to exercise. So I've sort of seen firsthand both that setting up of that agency and, just interestingly, following on from what Jono had just been talking about, that there's more than just putting it in the legislation. There's also a whole multi-year process that you have to think through about how you're going to transition one function into another agency and all of the things that you need to do to support that and make sure it happens properly and efficiently.
Yeah, so it's not completely vanilla. It's had to incorporate a change process too, which is another important consideration why we like to kind of bring some of those real life examples into our webinars. So let's move on from there, because in many of these cases, legislation is actually necessary. You can't just rely on the common law or just some of these entities being natural persons. So when should legislation be used, Jonathan?
Thanks. Thanks, Guy. I think the way you frame the question really starts to give us the answer, which is that it's a matter about going back to first principles and asking, is legislation necessary to do this, or is there some other way or mechanism that it might be done by? And in the case of new entities, legislation may be necessary because you want to confer a particular function, whether that's statutory or otherwise, that doesn't otherwise exist. You want to grant the entity powers that would not otherwise have by virtue of being a legal person. Some functions can be carried out by companies and corporations, but if you want to give them particular powers, particularly coercive powers, then you'll need some statutory overlay to do that. You might also need legislation to establish appropriate governance and accountability mechanisms, particularly ones that will be enduring. You might want to give statutory recognition to the body for the reasons that Dagny talked about before when she talked about persuasion, in terms of giving it more heft. And also there'll be cases where that's necessary to comply with New Zealand's international obligations when it's agreed to do that by treaty.
Yeah, that's great. And I'm particularly attracted to the appropriate governance and accountability arrangements given my day job, but I digress. So we end up in a situation, though, where we've kind of worked through a little bit about what those powers should look like, whether legislation's required or not for a new entity to have those powers and so on. If we can turn to Dagny now and sort of talk a little bit more about the form that a new public body should take. How do we go about that and how do we think about it?
Well, I think the overarching principle here is that the entity or body that's exercising a public power should have accountability arrangements appropriate to that power or function that's being performed. So the form needs to be consistent with and appropriate to the function that is being carried out. So we have already a number of existing organisational forms that are well established and well understood in terms of their accountability arrangements. These are often provided for in legislation, and these are things that we can look to and use, and indeed we should use them. Participants today will be familiar with many of these forms, such as departments, departmental agencies, or Crown entities, such as independent Crown entities or Crown entity companies. These are all part of the available types of forms that already exist. And if you want to go outside of that and create something that is novel and hasn't already been used, you really need a strong justification for doing that. The starting point in any analysis about form is understanding the context for the government's involvement in this particular area or activity. If the government is already involved, what form does that involvement take? Does it need to be the same, or should it be different? If it's not involved, why is it decided as a matter of policy to now become involved in that? And what does that tell you? Once you've worked out your context, there are 6 main questions to consider when determining the type of entity or body that you want to create. So bear with me while I run through the 6 considerations. So the first one is asking about the role that the entity is going to be required to undertake. How does it relate to central government, and how does it relate to the other entities that are already acting in this space or system? Second one is, what are the specific objectives and functions of that entity? The third question, what powers are necessary to achieve these objectives and functions? We've already talked about that a little bit. The fourth question is, how is the entity going to fund its activities? This is going to have implications for what form you want it to take and what the accountability should be. Fifth thing is, what are the risks? How crucial is the role being played by the entity, and what are the consequences of failure? And the sixth consideration is asking about what type of governance arrangements are necessary. You will need to think about what degree of ministerial oversight is required. Is it essential that there's political accountability, or is freedom to operate without political interference more appropriate here? For example, some types of commercial operations. And another one to think about is some kind of external oversight required. Do they need to report to some other body or a parliamentary body, for example? Chapter 20 of the legislation guidelines sets out the types of entities that you might want to use and the types of functions that these usually perform. The Public Service Commission also has guidance on how to identify organisational forms and understand which one might be the most appropriate for the particular functions you are seeking to create. And we, LDAC, recommend that you take time to review that guidance when you're considering creating a new entity. The last thing here is that officials also need to be aware of existing legislation that applies to all new and existing bodies. So this is the kind of legislative backdrop that already applies to anything that you're creating, and you should not only be aware that it does apply, but also think really hard about whether you need to exempt it, because the presumption is that it should apply. And those are things like the Ombudsman Act, the Official Information Act, Local Government Official Information and Meetings Act, the Public Audit Act, the Public Records Act, and the Privacy Act.
Interesting, isn't it? As we've been talking, I'm thinking, about two things in particular. One is just how involved creating a new body actually has to be. It's not as if sort of a minister or senior officials could suddenly dream up one day that they want a new entity, and lo and behold, there it is. There's a whole bunch of considerations. The second thing which strikes me in terms of change over the course of the last 20 or 30 years is we now have a set of various legislation around various types of bodies, and we've moved well and truly away from having bespoke pieces of legislation. So just to pull all those threads together, a new public body should be created only if no existing body possesses the appropriate governance arrangements or is capable of properly performing the necessary functions. Legislation should ensure appropriate accountability arrangements that are best suited to the relevant functions. And finally, and to reinforce Dagny's point from the latter part of what she's talked about, all public bodies should be subject to the Ombudsman Act, the Public Audit Act, the Public Records Act, the Official Information Act, or the Local Government Official Information and Meetings Act, and the Privacy Act. And that's only, I think, a list for starters. So we're about 2/3 of the way through our webinar today. Just a quick reminder, if you've got questions, please use the Q&A button at the bottom of the screen. We've already got a few, but if you've got a few others, then please ask those questions using the Q&A button. Now we're going to just finish off the panel session today by talking about creating powers of search, surveillance, and seizure. And Dagny referred to those briefly earlier in the webinar. So maybe I can turn back to Dagny and say, what are the search powers and when might they be necessary?
Thanks, Guy. So search powers is really an umbrella term that's given to a range of powers that can enable an individual or an entity to enter, search and survey or seize property, but that's kind of at the very intrusive end of the scale. But at the other end of the scale, it includes powers to compel the production of information or to require people to answer questions. So this is an area of law that engages the Bill of Rights Act, and one of the first things that you'll need to do when you're thinking about giving a new entity search powers of some type is to do a Bill of Rights Act analysis. And this will help you to flush out some of your legislative design questions as well. So search powers enable regulatory bodies and law enforcement bodies to promote compliance with the law. However, they can have slightly different characteristics depending on whether they are for regulatory or for law enforcement purposes. And it's really important that you understand the differences between those when you're setting them up. So searches for regulatory purposes aim to promote compliance with the law through things like inspections, monitoring, enforcing compliance with legislative regimes that regulate particular industries or activities, and particularly in cases where non-compliance can result in harm to the public or to the environment or the economy. And in contrast, searches for law enforcement purposes aim to gather evidence for the prosecution of offences. Search powers for those two purposes, as in law enforcement and compliance, exist on a spectrum. Sometimes there can be a fuzzy area in between them where there's no clear demarcation. So the clearer you are in your policy thinking about what you're doing and why, the easier it will be for you to understand whether you're talking about law enforcement or regulatory compliance powers.
Yeah, that really nicely sets the scene for this part of the webinar, really, in terms of those new powers. And I remember when the current search and seizure legislation was passed, it brought together a whole bunch of stuff, which we'll talk about in a moment. But there was quite a lot of excitement around that, even if it didn't actually change what those powers were. And a lot of that excitement was about infringement on property rights and so on. So I thought I might turn to Jonathan, and can we talk a little bit about what the search powers must be balanced against, and what can the consequences of balancing that in the legislative design be?
Thanks, Guy. Of course. As you say, search powers have to be balanced against other important social values. These include respect for liberty, dignity, bodily integrity when you're talking about more invasive searches, such as taking samples from people's bodies, privacy, and people's right to have a peaceful enjoyment of their personal property and their personal lives. And these are really the values that underlie and are reflected in Section 21 of the Bill of Rights Act, which Dagny deals with, I'm sure, all the time, which protects individual from unreasonable search and seizure. And it's important to do this policy thinking, design it well up front to make sure that the balance is struck right, so that the agency has the necessary tools that it needs to give effect to the policy or an act without unjustly interfering with those other rights. And poor design in this space can lead to unjustifiably intrusive or insufficient powers, so it can tip the balance one way or the other in terms of its effectiveness. And doing that can make the act difficult to use, can result in inconsistent exercise of the act or the powers, and be subject to challenge as a result in the courts. So that potential to have the potential, if they're not done well, to undermine the whole operation of your regulatory regime. There is, however, good news for our participants that are involved in designing regimes. And as you said, Guy, the reform of the law of search and surveillance in 2012, with the passing of the Search and Surveillance Act, has consolidated a lot of existing police powers that were previously in multiple different pieces of legislations, and set out detailed procedural rules and safeguards that apply to both the exercise of police powers and also the majority of powers held by non-police regulatory agencies. Those powers themselves will remain in agency-specific legislation, but they become listed, or they are listed, in the Act. So in this way, much of the work has been done for you, and the starting point is therefore that any new legislation which creates new search powers will need to contain a specific statutory provision that applies Part 4 of the Search and Surveillance Act to link into that work there.
And there's a really nice pattern emerging in our webinar and conversation today, and that is that for both policy analysts and legal advisors, there's now a set of legislation that actually allows the policy advice to proceed on the basis of some really, really built ways of looking at this stuff rather than having to start from scratch. What's interesting about this search and seizure surveillance question is not only what that is and how you pick and mix from the Search and Surveillance Act, but who holds those search powers. So, Dagny, who should be permitted to hold search powers, and what safeguards could be put in place?
So, Guy, as with all powers, search powers should be held by people who have the appropriate level of expertise and accountability to wield them. The more invasive the power, the more expertise and accountability is required. So at a practical level, the person exercising the search power must have access to the information required to assess whether the threshold for exercising that power has been met. Often there's a very specific legal test about when you can use a search power. So it's got to be somebody who can have that information and can know whether that test has been met. And they have to have sufficient training and expertise to carry out a search. To ensure accountability, officials should consider whether the person exercising the power will be subject to sufficient safeguards which are appropriate to the nature of the decision and proportionate to the invasiveness of the power. Safeguards can include one or more of the following things, such as oversight or supervision of the exercise of that power by someone with higher levels of accountability. And it's important to note here that all searches that are carried out for law enforcement purposes should be done pursuant to a warrant. So there should be some process to get a warrant from a judicial officer or another issuing officer in order to get that warrant. That's your oversight and supervision in that case. And you need to do that unless there's some really super duper good policy reason why that's not workable in this situation. The other safeguards you can have are requirements to report publicly on the exercise of those powers. That provides a level of transparency. You could also have a safeguard which required the holder of the power to be subject to investigation by the Ombudsman or to be subject to the Official Information Act. Those are other types of transparency. You may also have rules built into your legislation about what the entity can do with the information that it acquires as a result of that search. So they can, the purposes for which they can use it can be very tightly circumscribed. And the other thing is, of course, is to think about what your legal test is for exercising the power and when it should be able to be invoked.
Yeah, so it's actually quite involved, and you need to work through a bunch of those things to ensure those safeguards are there. So let's just finish off with one last question to Jonathan, in terms of the panel part of the conversation at least. So what are some pitfalls that officials should be mindful of when designing search powers?
I think the comments that Dagny's made just before pick up on this really, because like any other area of the law, uncertainty isn't our friend in this area and can create pitfalls for us. So the types of provisions that Dagny was talking about being clear about what the information can be used for and how it can be held, are the kinds of things that, if they're well built in, will avoid some of these problems. It also relates back to the point that Dagny made earlier about being aware of the scope of the powers and the purposes they're used for. She reminded us earlier of the difference between regulatory purposes or monitoring purposes and powers for investigative purposes to gather evidence for the prosecution of offences. And as she made the point, that while these can appear to be similar on the surface, they've got different purposes which underline them. And being clear about what the nature of your powers are and when they're intended to be exercised is one way to avoid some of those pitfalls. And regulatory regimes can get into trouble when they're not clear about that. For instance, given that monitoring powers are less administratively burdensome, there may be a temptation for a regulator to rely on these when they expect to find a breach of an obligation. But that's a circumstance in which you may find yourself being challenged afterwards if you get into that sort of situation. So again, I think it comes back to the key message that clarity of purpose about the powers and how they are to be exercised is the best way to avoid the kind of pitfalls that you can see in a poorly designed regime.
So hopefully, in terms of this conversation about search and surveillance powers and the safeguards and so on and so forth, we've given our participants today a bit of a roadmap for how to think about something that's really important and can be pretty invasive and doing the right thing and not creating uncertainty. So just to pull the threads of that together, new search powers should only be granted if the policy objective cannot be achieved by any other means. New search powers should apply the rules and procedures set out in Part 4 of the Search and Surveillance Act 2012, and we've talked about that and how useful that is in bringing all of those things together. Search and surveillance powers should be held by a person with the appropriate level of expertise and accountability. And you'll note we've talked about expertise and accountability in terms of the creation of a new body as well. So that's a common theme across our webinar today. And lastly, legislation should make clear what powers are able to be utilised and the purpose for which they are able to be utilised. So that brings us to the end of the panel conversation. Just a